In this video, we will discuss about legal rules regarding a valid offer. The question can be asked like essentials of a valid proposal. So you should able to differentiate the essentials of proposal or offer versus the essentials of valid proposal. The essentials of proposal is only 4 points and it is coming from the definition itself, whereas essentials of valid proposal are 10 pointers. So it can be asked for 2 marks, 4 marks, or 6 marks. Let's discuss the legal rules. The first rule is it must be capable of creating legal relations. A social relation will not be considered as a valid offer. So, what is social relationship? A husband promised to wife, a daughter promised to father, mother promised to her son. So, all these are social relations. Okay. So, if they exchange or they made a promise, it is not a valid offer. So they should come together for establishing, for creating legal obligation, legal relationships. The reason being to become a contract, agreement plus enforceability. The transaction in which a contract is made should be enforceable in the court of law, should be valid in the court of law. That is the major reason. An offer while you are making, the objective behind offer should establish legal obligations to create legal relationships, but not social relationships. This is the first legal rule. The second legal rule, it must be certain, definite, and not vague. So A want to sell his car to B. Which car? At what price? When? All these questions. A want to sell wheat. How much? At what price? On which date he want to deliver? So from how many days he is expecting a payment. All these terms and conditions should be clearly mentioned, clearly documented. It should be certain, it should be definite, but not vague. The third legal rule is it has to be communicated to the offeree. It has to be communicated to the offeree. There is a case law which is Lalman Shukla versus Gauri Dutt. So Lalman Shukla is the owner and Gauri Dutt is a servant. So Lalman Shukla lost his nephew, lost his child. So Gauri Dutt went searching for the child. Meanwhile, Lalman Shukla gave an announcement, an offer to the public that he want to give an offer, give an amount of rupees so and so if they could able to find, if they could able to find the nephew, his child. So Gauri Dutt is not aware of this offer. He bring back the child. Can Gauri Dutt able to claim the money? In this case, no. Who won the case? Lalman Shukla. Why? What is the basis? The basis is Gauri Dutt went for searching of the child, searching of Lalman Shukla's nephew without knowing the offer. Without knowing the offer. It was not communicated to Gauri Dutt at all. So Gauri Dutt cannot claim the money from Lalman Shukla. So the offer should be communicated to the offeree. So when there is no communication, there is no offer. So if you recall the definition also, willingness to express to offeree and also provide assent of the offeree, assent of the offeree. So here it never reached to offeree. It never reached to offeree. So when there is no communication, there is no offer. That is the third legal rule. The fourth legal rule is the communication should be made in such a way to obtain the assent of the other party. So this is coming from the definition itself. So the communication, the offer was made in such a way to obtain the assent of the party, to obtain the acceptance of the party. This is coming from the definition itself. So the third and fourth point are common in case of essentials of a proposal as well. So you could able to remember the third and fourth point from essentials of an offer or from the definition itself. The first and two are from the contract, the essentials of a contract. So when we have discussed the essentials of a contract, we discuss these 2 points. So the first point is the offer should be made to create legal relationships. The second point is it should be certain, definite, but not vague. So let us move to the fifth point. So fifth point is it must be conditional. So often should be made with all the terms and conditions. What are the terms and conditions? It has to be dispatched on this date. It has to be priced at this price. It has to be paid on so and so date. So it has to be clear. So the second and fifth point are interrelated. An offer should be made with all the terms and conditions. So next we'll move to the sixth point. The offer should not contain a term, the non-compliance of which would amount to acceptance. So you cannot make an offer that, let us say, if you don't reply in 7 days, if you don't reply in 10 days, that is a deemed acceptance. That is a deemed acceptance. You cannot have such terms and conditions. So you send a letter to B to enter into a contract. If he does not reply in 10 days, we will take it as a deemed acceptance. You cannot have such things as non-compliance can lead to an acceptance. So that is your sixth offer. That is your sixth rule. The seventh rule is an offer may be either be special or general. So we have discussed kinds of offers where the offer can be general offer or a specific offer. General offer is made to public at large. Special offer is only to exclusive people. The eighth point is also the offer may be express or implied. It can be expressed in the form of words or in the form of writing, or it can be in the form of implied, which is by the act, by conduct of the parties. So seventh and eighth point, we could able to remember with the help of kinds of offers. We have discussed seventh and eighth point in kinds of offers. Next, you have ninth and 10th, which are talking about the offer is different from mere statement of intention, an invitation of offer, a mere communication of information, a prospect and advertisement. So what does that mean? Let us say there is an invitation to offer. So you have seen some hoardings, you have seen some pictures um, in front of the shops that up to 50%. So they are telling up to 50%. That means it can be 10%, it can be 20%. They have not mentioned about the products. Let us say it can be for different products in the shop which are available in the shop. So it is just an invitation to offer. It is just an invitation to offer. It's not an offer. So what is the difference between invitation to offer and offer? We'll understand more details about that in the next coming slide, but we will see few examples. Let us say prospectus. So prospectus is invitation to offer, but not an offer. And many advertisements are invitation to offer, but not offer. A price tag on the product is invitation to offer, but not offer. So it, what is the difference? The main difference is the intention behind giving an invitation to offer versus offer. The intention behind invitation to offer is to call for negotiation, to call for a discussion, to come to a conclusion and to bring to an offer. The intention to make an offer is to obtain acceptance. So the result of invitation to offer leads to offer. The result of offer leads to acceptance or promise. Hope it is clear. I would like to repeat. In case of invitation to offer and offer, you need to see the intention. So the intention is to negotiate. If the intention is to negotiate, then it is an invitation to offer. The intention is to provide or obtain assent from the other party. We call it as offer. So we need to see the intention. So we have covered few examples. I want to repeat the examples also. The price tags mentioned on the product, the prospectus, and many advertisements. General advertisements, we call it as invitation to offer, but not an offer. So what is an invitation to offer? It is only a circulation of an offer, and it is an act precedent to making an offer. Before making an offer, you make an act, you make a activity which is precedent to making an offer, and it is an attempt to induce offers and precedes a definite offer. So it is before offer. It is before offer, or the invitation of offer ends with negotiation, and finally it ends with offer. So the acceptance of invitation offer does not result in contract, and only an offer emerges in the process of negotiation. So the end point of offer is acceptance and eventually turns into a contract. Whereas in case of invitation of offer, it will go to negotiation and then finally it becomes an offer. So this is the point number 9 and 10, which talks about invitation to offer. So you need to distinguish between offer and invitation to an offer. So we have discussed 10 rules. Let us quickly revise those 10 rules. What are those 10 rules? The first rule is you made an offer to create legal relationships, but not social relationships. The second point is it must be certain, definite, and not vague. And it has to be communicated to the offeree. No communication, no offer. It must be made with a view to obtain the assent of the party, coming from the definition itself. It may be conditional. You should have all the terms and condition. And mere silence is acceptance. It is mere silence is not an acceptance. So it should not have a term where the non-compliance will lead to acceptance. It can be general or special or specific. It can be express or implied. And then an invitation of offer versus offer, both are different. Let us see the differences between offer and invitation to offer. So the meaning, so the definition of offer is coming from section 2A. We have already discussed. Whereas the invitation to offer, let us discuss, where a party without expressing his final willingness proposes certain terms on which he is willing to negotiate. He does not make an offer, but only invites the other party to make an offer on these terms. So you are giving few pointers in a way to grab the attention of the offeree and to call him for negotiation. That is invitation to offer. So here the intention of the parties is to obtain the acceptance in case of offer. Here, just to negotiate and call for to make an offer. And the sequence, which is prior, which is after, an offer cannot be an act precedent to invitation to offer, whereas an invitation offer is always an act precedent to offer. So it starts with invitation to offer, then to acceptance. It cannot be offer, then you have invitation to offer. Hope these 3 points are clear. So how to remember, how to recall all these 10 points? Let us quickly discuss. So the first 2 points are coming from essentials of contract, and the second 2 points are coming from essentials of proposal. 5 and 6 are different from what we can recall. 7 and 8 are coming from a kinds of offer. 9 and 10 are offer versus invitation to offer. So if a question comes for 2 marks and 4 marks, you should be able to write 6 pointers. So where the 6 points or 8 points you can easily remember. 2 are coming from essentials of contract, 2 are coming from essentials of proposal, the other 2 are coming from kinds of offer, and finally the offer versus invitation to offer. Hope it is clear. This is how you need to remember all the 10 points of legal rules of a valid proposal or offer. With this, we end with the offer. We will discuss the fifth subtopic of this chapter or this unit, which is acceptance. So we completed discussing history, definitions, contract, and offer. Now we are discussing acceptance. So in case of acceptance, there are 3 points, which is first is definition, second is relationship between offer and acceptance, third is Legal rules regarding a valid promise or acceptance, or we can also call it as essentials of valid acceptance. What we have just discussed is valid offer, legal rules of valid offer, essentials of valid offer. What we are going to discuss is legal rules regarding a valid promise, essentials of promise or acceptance. So definition, you could able to recall, we have discussed in definitions part. Let us discuss relationship between offer and acceptance. Relationship between offer and acceptance. So according to Sir William Anson, the offer and acceptance, how are they related? They are related. Acceptance to offer is what a lighted match to a train of gunpowder. Acceptance to offer what a lighted match is to a train of gunpowder. So you imagine a train of gunpowder and you lighted it with a matchstick. You lighted it with a matchstick. Okay. So what does it mean? The moment you give acceptance to offer, it becomes contract. The moment you give acceptance to offer, it becomes a contract. Hope it is clear.